Hi everyone, welcome to today's show, Let's Talk Real Estate. I'm your host, Anthony Giglio. I am a realtor at RE/MAX Legacy here in Woburn, and I am excited to have today as my guest, Michael Callahan, an attorney at Sigmund Law Office in Stoneham. Michael, welcome to the show.
Thanks for having me, Anthony. I appreciate it.
I'm so excited that you're here with us today.
Sure.
Michael, maybe you could just tell us a little bit about what you do, what your role is in a real estate transaction.
Oh, sure, Anthony. Before I do that, though, I'd like to introduce myself again. I'm Michael Callahan from Sigmund Law Office at PC and Stoneham. My practice areas are specifically focused on real estate and estate planning. And when it comes to a real estate transaction, especially with regards to a purchase transaction, oftentimes I begin the process with helping the buyer negotiate the offer and also negotiate the purchase and sale agreement.
Excellent. So you're kind of a vital part of the whole real estate process.
Well, you know, I should be a vital part. Sometimes people will forego the need for an attorney, but you have to remember when you are signing an agreement or a purchase and sale agreement to purchase property, it's a legally binding contract. Just like as if you were purchasing a business, or if you were entering a contract to create a business with somebody else. And in those regards, you really should have legal counsel.
Yeah, it's very important to be represented.
It is.
Already represented.
It is. It's one of the. It will be one of the biggest, if not the biggest, purchase of someone's life. And in the end, it'll be, if not the most valuable, but one of the most valuable assets a person owns.
Right. And I actually work with many clients who think that they can do this on their own. That they don't need an attorney. That they can review all these legal documents on their own.
Right.
And they very well may be able to.
Right.
Just to save a few dollars. But like you said, this is the biggest financial investment of someone's life. Mm-hmm. And to have someone who is a professional and who is accustomed to looking at all this legal documents mm-hmm. to protect someone's deposit, mm-hmm. to protect someone's interest in that property, it's important to just not to worry about saving a few dollars.
It is important. In Massachusetts, the purchase and sale agreement is a pretty standard document. There are 3 or 4 different versions of it floating around. I'm sure you've seen different versions
sure.
of it. But I mean, for the most part, it is standard. It's when an attorney on one side starts to make revisions to it, to benefit their client. Well, if that's the case, if there's certainly an attorney on one side, then there should be an attorney on the other
right.
side. Right. Attorneys add addendums to the purchase and sale agreement which kind of draw out some more factors that need to be considered with the closing and mm-hmm. Things that need to be accomplished prior to the closing. The standard purchase and sale agreement is a fine document, but it does have its strengths and weaknesses.
Right.
Yeah.
And certainly this purchase and sale agreement you speak of,
yeah.
It is kind of filled with a lot of legal terms.
Certainly.
Something the simple man like myself doesn't understand.
Right.
Even as a real estate agent, I don't understand a lot of some of the language in that document. Mm-hmm. So to not be represented for that document, it's kind of it's not recommended.
It's definitely not recommended. If you can afford to have an attorney help you with it, then you should. And either on the purchase side or the sale side, if you are a seller of a property, the attorney will help to revise the purchase and sale agreement to better fit your circumstances, and also the attorney will also help you in the end with if there's any title issues
right.
with regard to the property that need to be cleared up before the closing. And then on the buyer side of it, they're going to make sure that the purchase and sale agreement fits in with your financing, make sure you're protected in case the sale doesn't go through, mm-hmm. Like you alluded to earlier, by protecting your deposit. So it is important. It is important.
One thing that has come up several times with some of my clients is, can any attorney represent someone on a real estate transaction, or should it be specifically someone who deals with real estate?
Well, that's a great question. And in Massachusetts, when you hold a law license, you can practice law in any area.
Sure.
Whether or not you should practice law in any area is a different question. Like I had mentioned at the beginning, I specifically focus in estate planning and real estate, but I'm not out there defending a drunk driver, or I'm not out there suing somebody for a tort claim.
Right.
And I think that when you engage an attorney for a real estate transaction, it should be someone who's involved with real estate. You know, it should be a good portion of their business, not 10% or 15%,
Right.
but it should be up there, you know, with 30, 40, or 50%.
Mm-hmm.
Yeah.
And I've seen personally where attorneys who aren't versed necessarily in real estate
Yeah.
have taken on a real estate transaction and have kind of messed the deal up because they didn't really understand everything that they needed to for the real estate transaction. So it was very important, and I tell all my clients that when you hire an attorney, make sure that real estate is their main focus.
Right, you know, and oftentimes, not oftentimes, but every once in a while, what'll happen is that on my side of the transaction, you know, being versed in real estate, things seem to be going smoothly, but on the other side of the transaction, they instead decided to have their niece or nephew or uncle represent them, and that person necessarily wasn't a real estate attorney, and so it alludes to what you were talking about, where, you know, they just missed something, or they're not exactly sure how to complete something, or
Right.
or to fix something.
Right.
Yeah.
I kind of compare it to, I'm a real estate agent. I am licensed to sell real estate and lease real estate. I do primarily residential, but I also can do commercial. But I'm not versed in commercial. If someone wanted me to help them with a commercial transaction, buying a business or leasing out some space, I'm licensed to do it, but I would not be the best person to handle that transaction because residential real estate is my specialty. So it's kind of similar. You know,
Sure.
just because you're an attorney doesn't necessarily mean that you're qualified to handle a real estate transaction.
That's right. So it is important to review the attorney's credentials and their background, and and maybe even a referral may be the best way.
And you are specifically real estate attorney.
I am. Right.
Excellent.
That's
So now we understand why Michael is relevant, and it's great. And
That's
so
right.
I want to kind of jump right into our topic today, and it's called "We Must Protect This House," the topic of our show today.
Yeah.
That phrase has been coined by Under Armour. It's a clothing line, but it's kind of apropos because you're kind of the Under Armour of the real estate transaction.
That's right.
Protecting the biggest financial investment of your life. And there are several ways someone protects that investment. And I know we had talked before the show about a few of them, and I was wondering if we could just have a discussion about some of those ways that someone can protect their investment.
Absolutely. I'd be more than happy to discuss some of the major topics with regard to protecting your investment. A lot of it is a mystery sometimes for people, in whether that's because it hasn't been explained to them before the purchase, or it's not explained to them during the purchase process. It's important to ask questions when you're a buyer,
Right.
Even more so than when you're a seller, I think, because
Sure.
here you are purchasing something, especially if you're a first-time homeowner or first-time purchaser. I mean, it's a brave new world.
Right.
Yeah.
Right?
Yeah.
Absolutely.
Yeah.
One of the biggest questions I get at a closing table is this title insurance. It's this big, usually the biggest portion of your closing cost is dedicated to title insurance.
Right.
Not anyone, most people, I wouldn't say anyone, but most people don't understand what it is.
Right.
And the purpose of it and why they have to pay it. And I'm hoping you could kind of explain a little bit about title insurance and examining title, because that's kind of
Sure.
An important part of the real estate
Sure.
attorney transaction.
Absolutely. So title insurance is a very broad topic, but to hit on some of the major components of it here would definitely fit into our time frame. So when someone wants to purchase a property, whether the closing attorney, which is actually the attorney who represents the bank or the lender, but that attorney can also represent the buyer in a dual capacity. It's their duty to research the title of the property. And they do that by visiting the Registry of Deeds and researching the title of the property back 50 years. Okay?
Wow.
So, that would bring us back to 1962, correct?
It's I think it's good math.
Yeah. And so what they do is they go all the way back to the.
I'm a real estate agent,
I know,
not a
I know you are.
mathematician, Michael.
I know. So they go back to the deed, and then they work forward to see if there's any issues on the property. And you could have old mortgages. You could have, if someone was ever sued, you could have an attachment or an execution. They want to make sure that the deeds are in order, that the deeds were signed. Just very simple things to make sure that the property wasn't deeded out to somebody else during the time period. And make sure that there's what's called a chain of title. All the links in the chain link up to create a title chain. Okay, and ordinarily there's no problems, or if there is, it's something that can be cured. Okay. What would happen is that the closing attorney would go back to the seller or the seller's attorney, hopefully, and say, this is an issue, we need to get this fixed. And the seller's attorney would be engaged to help fix that, okay? When the closing is completed, the closing attorney issues what's called a certification of title. It's required by Massachusetts law. And that closing attorney is saying, to paraphrase, I've looked at the title appears perfect, okay? I'm gonna sign this as an attorney saying that your title's perfect and you should feel comfortable with that.
Sure.
Well, that's one part of it, and that's the most minimal type of protection you can have.
Right.
Now, when you're buying a property and there's a lender involved, there's two types of title insurance. There's a lender's policy, and a lender will always require that their interest in the property be insured by title insurance. So not only are they just going to rely upon the attorney's certificate, they want something more, okay?
Right.
And there's also an owner's policy, and they can be purchased simultaneously. It's the responsibility of the buyer to purchase both. The lender requires that the buyer purchase their policy and also their own owner's policy. So what does the owner's policy do? Well, from that day forward, it protects your interest in the property, okay? And it protects you backwards as well, okay? It's a one-time premium. You don't have to pay an annual fee.
Right.
You pay it lump sum, and it covers you for as long as you own the
life.
property. For life, that's right. So what are some of the things that it protects you against? Well, it protects you against things that maybe were missed in the title search at the Registry of Deeds.
So if for argument's sake,
Yeah.
you didn't do your job correctly,
Well,
or is it something that
yeah, no, that's
there was some
right.
document hidden somewhere
Right,
that couldn't
right.
be found that surfaced later?
Those are two great examples. So, attorneys are humans, right?
Right.
And everybody makes mistakes. So
Sure.
if, hopefully it wasn't a very crucial mistake, but it could be made. And if that was the case, if they did miss something in a title search, then the title insurance would help, you put in a claim, and that would clear that issue up. The title insurance company has attorneys and title researchers and companies they work with would work together to get that cleared.
Sure.
Another issue is that the people who work at the Registry of Deeds are humans as well. So something could be what's called misindexed. It'd be very similar to the library, where a book starts with B, but it was put on the Z shelf instead.
Right.
And that could happen as well. So in the title review, the attorney is responsible for what's in the record. But if something wasn't in the proper record, then the title insurance would cover you there as well.
And I can see how that complicated that would be, because over a 50-year span, if you changed the property, 10, 15 different times, it was sold to 10 or 15 different people.
Sure.
The amount of transfer of title that you'd have to research,
Sure.
there's a good chance that maybe something got mixed up.
Or not even transfer a title, but think about how many times over, say, a 30-year span that someone refinances their house.
Sure.
Okay, so every time you refinance a house, there's a bunch of documents that go on.
Right.
If something there was put in under a wrong title, then the title insurance would cover you there as well. Does that make sense?
It makes perfect sense. Yeah. And lender title insurance is required.
Yes.
Owner title insurance is optional.
It is optional.
Would you recommend it?
I would always recommend it. As an attorney, I've seen what can happen when you don't have insurance, and whether it be title insurance or homeowners insurance or auto insurance, it's always better to be insured than not. And again, it's a one-time payment, and in my practice, 95–96% of people purchase it. Yeah.
So let me ask you this, because a lot of people think, it's just an expense that I shouldn't pay, and I don't really want to, spend that money. But have there ever been instances in Massachusetts or even around the country where title insurance protected someone, or someone didn't get title insurance and someone that made a claim against their property and they lost? Yeah,
well, sure, certainly. There's claims made every day on title insurance, and what happens is you don't usually realize you have a problem until a title search is conducted. So whether you're refinancing the property or you're about to sell the property is when you realize there's a problem. And so then you have maybe 3 or 4 weeks to try to clear this problem away. And a typical instance is where you own the property. Let's say you've owned it for 10 or 15 years and you've refinanced it 3 or 4 times. Well, now you go to sell the property or to refinance the property, and the closing attorney for the bank says to you, well, I see a mortgage on here from 12 years ago. Is this mortgage paid off? And of course you're taken aback and you say, of course it's paid off. And you have documentation to show that it was paid off. You have maybe those closing documents from that closing. However, the discharge of mortgage, which is a separate document that the bank issues once they're paid off and gets recorded at the registry of deeds, that clears the mortgage off. It didn't get on record.
Right.
Or maybe it was misindexed.
Right, absolutely.
Okay.
And we're kind of going through that right now with one of my clients. You're representing one of my clients, and they have a few mortgages
Right.
that have not been discharged.
Right.
Some of them are legitimately not discharged, and some of them have been discharged, just not filed properly.
That's correct. So,
and you were able, to catch it.
yes, we did catch it. Sometimes a lender will send the discharge to a client directly, which is not a great thing because the client just thinks it's a document and they file it away. But in actuality, that document needs to be recorded.
Right.
So it's nice when we can find a discharge and get it on record for the client. But if it's a long lost bank, or a bank that's merged into a bunch, like Fleet merged into Bank of America,
Right.
or Bank Boston merged into Fleet, well, then it takes a little bit of legwork to find the proper entity to
I
discharge
would
it.
imagine there's a lot of that going around,
There is.
especially with all the bank industry over the last century.
Right, right.
Like you said, merging and non-existent banks anymore.
Exactly. And it is often, sometimes when a discharge does make it on record, but it's there's a mistake in the discharge, which is really, really a pain in the neck.
Yeah.
Because, they did what they were supposed to do. However, there's a mistake, so you have to go back to the bank now and get it revised. So that's a common problem. And what we try to do is work with the attorney who did the closing, who was responsible for the discharge, and to see if they have it, or if maybe the client has it. And if that doesn't work, what we do then is we put a claim into the title insurance company. The title insurance company will issue a letter saying it's okay to go forward with the closing. We're going to handle finding this thing. So it doesn't put the brakes on the closing. It allows the closing to continue, and you have a letter, guaranteeing you that the title insurance company will take care of it in the future. Okay.
Absolutely.
Yeah.
So this insurance, title
Yeah.
insurance,
Yeah.
kind of crucial. It's an important.
It is, because let's say it is a lot of money. It can be. When you bought the house 10 years ago, you paid $1,200, say, for your title insurance. Okay. Well, if 4 weeks, if you get that call 4 weeks before you're supposed to close, and all of a sudden you have to chase this discharge down and hire an attorney to do it, well, at $200 or $250 an hour,
I'm in the wrong profession.
but if they're trying to chase this discharge down,
Sure.
right, and you're paying for it, what if it goes to 7 or 8 hours? You're up
Right.
to $1,600.
Sure.
So you can see the cost benefit there.
Absolutely.
Yeah.
I think we've talked about title insurance enough.
Okay.
I want to talk about another important protection you can have for your house, and that is the homestead.
Sure.
This is something I'm passionate about because I just refinanced, and I realized I didn't have a homestead. And I remember when we were talking, a few months ago, you and I were discussing the importance of a homestead. And I was telling everyone, you have to have a homestead. And then when I went to refinance, I realized that I didn't have one on file. So I immediately filed one. So could you explain what a homestead is?
I can, sure. So the homestead law actually changed in March 2011. And before that, it was kind of a hodgepodge of laws, and it was a lot of gray area, and people really, even attorneys, didn't know exactly how it worked. So a new law was promulgated, and it took care of all the gray areas that once existed and sort of cleared everything up.
Sure.
And the new law provided that you actually don't have to file anything to be protected. Okay, so just by owning a home, and you are protected up to $125,000 of equity against a creditor. All right, but if you fill out a certain form and file that at the Registry of Deeds, you could be protected up to $500,000.
Let me stop you right there for a second. When you say protect you against a creditor, what exactly do you mean?
Sure. So what a homestead does is it protects you against an attachment, a seizure, an execution on judgment, a levy, or a sale of the property.
Okay,
And
those are all legal terms.
Right.
Can you
But it's
simplify
very,
it for
sure,
our audience
Sure, it's
today?
important that we talk about those things. So
Sure.
let's say you are you're getting sued for some reason, okay? Well, they can put an attachment on the property saying, we intend to take this property if we win the judgment.
Say you don't have enough money to pay for the lawsuit, they can go after your house.
Exactly.
Okay.
Right. Or in another circumstance, let's say you were already sued and there was a judgment against you.
Okay.
Okay, that's called an execution, and that's put on record.
Okay.
And that basically says we're entitled to X amount of dollars from the property. Okay. So what's a scenario when something like that would happen? Well, a common scenario is an automobile accident. Okay.
Which happens just about every day.
Right. So an automobile accident, the other party was, say, personally damaged. There was some damage to their body, and your auto insurance coverage wasn't enough to cover that. Okay. So then maybe they would look to your homeowner's insurance with general liability policy, which I believe you'll be talking about in another segment.
Sure.
That wasn't enough to cover it. Well, there's this excess judgment. Well, they could put an execution on your property, saying when you sell this or refinance it, we're entitled to X amount of dollars. What the homestead does is it protects you against that.
So if you run out of money to pay for this judgment that's executed,
Or if your insurance runs out of money.
right,
Yeah.
then they can't come and now take your house.
That's right.
And take any proceeds from the house.
That's right. There are some exceptions to it though, and so the exceptions, the main exceptions are it can't protect you against unpaid taxes.
Right.
Whether it be city taxes, federal taxes, or state taxes, city property taxes, income taxes on the federal or state level.
Well, that's why they say two things that are always certain in life are death and taxes.
That's correct.
So
That's
you're
correct.
right. Taxes.
That's right.
Always
And
got to pay those.
The other thing that it won't protect you against is your mortgage. Okay, so the mortgage gets rights over the homestead, and a couple other things that it won't protect you against are if you didn't pay your child support. Also, if something was done fraudulently or under duress or undue influence, so if there was some sort of factors in there that,
Right.
so then it's not going to protect you because they're basically saying that that was done sort of not on the up and up. And then the last thing, which is really important, is that it won't protect you for anything that was on record prior to the homestead being recorded. Okay, so let's say you record your homestead in 2012. Well, there was something, a judgment or something like that, on record in 2011. It's not going to protect you. It's just going to protect you from the day you record it forward.
Sure. It doesn't go back like title insurance.
It does not go back like
Right.
title insurance. Yeah.
Okay.
Yeah. So the homestead, $125,000 if you don't do anything at all. At least $500,000 if you record it. And then there's an elderly homestead as well for people who are over 62. And so for people who are over 62, it's $500,000 per individual. So for example, if you had two 70-year-old people, husband and wife, living in a property, they could put two elderly homesteads on and they could be protected up to $1 million.
That's great.
Yeah.
You automatically get $125,000
With just by owning
just
the
by
property.
owning a home.
Yep.
But the average sale price in this area is a little over $125,000.
Sure.
Actually, in Woburn, it's about $330,000.
Right.
So you're only protected automatically for $125,000.
That's right. So you have the excess equity.
So there's a lot of money that they could go after.
Sure.
So to pay, I think it's like $25, $35.
$35.
To record a homestead, it's a no-brainer.
It is a
Probably
no-brainer.
the best $35 you'll ever spend.
And oftentimes an attorney will, as a courtesy, just prepare the homestead during a purchase transaction,
Right.
or even during a refinance transaction. If you don't have a homestead now and you wanted to put one on, then attorney might charge you a nominal fee just to research the title.
Sure.
And
But
to
still
prepare
worth it.
Yes,
Absolutely.
absolutely. Yeah.
Cool.
Yeah.
Have you ever had any instances where somebody didn't have a homestead and a catastrophic, accident happened or someone was sued?
Right. I don't personally, because I'm not in that area of law, which is more of a litigation type
Sure.
of area.
Sure.
So in that instance, the defense attorney would use the homestead as a defense to a creditor.
Right.
But there are certainly instances out there. But in my practice, personally, no.
Good. Well, that's actually kind of good. 'Cause
Yeah. Right.
You don't want to. You don't want people losing their homes.
No, I just make sure that we get the homestead on there.
Yeah, and that's probably why you don't have any instances, because you do tell all your clients to do homestead.
I do.
And if it wasn't for you, Michael, I wouldn't have a homestead on mine.
Good for you.
So I can get in car accidents.
Well, we don't
and
want
I'm
that.
safe.
Yeah, we don't want that. You're a bad driver anyway.
I am.
Yeah.
I am. So in wrapping up today, are there any other things that someone can do to protect their home?
Sure. Well, when you purchase a property and you're an individual, you hold title to the property individually. It's kind of elementary, right?
Sure.
But when you purchase a property with somebody else, there's different ways to hold title. And what this will do is make sure that your interest in the property passes to someone, the proper people, if you were to pass away for some reason, okay? So very basically, if you hold title with more than one person, you can either hold it jointly or as tenants in common, okay? Jointly would mean is that if someone passes away, their interest passes to the other people in equal share. So if you held it with one other person, the person who passed away, their share would vest in the person. They would own the whole thing. If they owned it with 3 people, say, the person passes away, it would be 50-50 to the 2 remaining owners, okay?
Okay.
Tenants in common is a little bit different. That's where you would hold property with someone maybe you're not related to.
Okay.
Okay, so jointly, maybe you hold it with your husband or your wife. There's a different way to hold it as well. Or you hold it with a brother or sister or a family member, and you want to keep it in the family per se, okay?
Right.
But tenants in common, let's say you and I brought a property together, 50-50, like an investment property. Well, there we would hold the tenants in common at the very least. And if I passed away, well, my interest would go to my family.
Okay.
Or not to you.
Sure.
Okay. And if you passed away, your interest would go to your family as well. All right.
Right.
And then another way to hold property is if you're married, it's tenants by the entirety. And that's a preferred way to hold it. What it means is that one of the spouses can't convey the property without the other one's permission. It's pretty important.
Right.
Yeah.
Well, what happens if one of the spouse passed away and you're tenants in entirety?
Tenants by the entirety, well, then the entire interest of the deceased spouse would vest in the surviving spouse.
Okay.
Yeah. So it's important to hold that the right way. I mean, there's numerous other ways to hold property as well, especially when you're dealing with investment type properties, you know, like LLCs or trusts, but that's beyond really the scope of this conversation. At the very least, you know, you should have it set up the way you want the property to flow, whether it be joint tenants or tenants by the entirety.
Now, is that something that an individual would decide at the time of closing, or?
Yes, it's usually when you purchase a property. It's usually the closing attorney's or the buyer's counsel's responsibility to let the seller's attorney know that when they prepare the deed, we would like the title to be held in this sort of fashion. It can be changed at a later date, but you're going to incur some recording costs and you're going to incur some attorney fees.
Do most home buyers know about this?
No, they don't.
Really,
it's up to the attorney to let you know.
Right.
And to go over what I just went over with you, the different ways to hold it and what would best fit your scenario.
Because I had no idea about any of this until I got into real estate, and you know, I studied for a real estate exam, and you know, coming with all these different tenants in common and tenants in entirety. So I would think that most people aren't aware that you can hold property in different ways.
You can, yes.
So it's very important that you kind of get a grasp of these, at least these 3 different ways.
That's right. That's right.
So, Mike, thanks so much.
My pleasure.
I appreciate it. If you have any questions about today's show, you can shoot us an email at letstalkrealestateshow@gmail.com. I'm Anthony Giglio, and I thank my guest Michael Callahan of Sigmund Law Office for being here, and we'll see you next time.